Hi, TJ here again for yourlaw.org. This article I put up, I wanted to be sure that just about anybody that wants to see it can see it. In order for you to see this article, and you're going to want to read it, you'll have to at least be a free member or premium member of our website. So you can learn about joining our membership right here at the Join or Upgrade coaching links and find out about the various programs we have there. Now, this document is so important because there are so many people out there in what we call the legal education movement, not the sovereign citizen movement, none of that, but just the legal education movement, where people are wanting to learn how to empower themselves and understand what's really going on. So I had come across this article some time ago. I edited it a little bit, added it to our blog so that it would be a good educational tool for anybody trying to understand how our whole commercial system works, because really it's not a legal system, it's a commercial system. And I'm not going to get into the history of admiralty and all that. I'm just going to try to show you some basic acts that happen and how our system operates under a method of bankruptcy law that essentially allows us to continue to generate revenue and grow and produce labor and produce credit and grow our economy. Now, why is that important from a legal standpoint? If you have a legal problem, that is. Well, it's because everything brought to you is a charge, and you can discharge those charges if you understand how the structure of the deal works. So my attempt here is to give you a basic understanding of how that all works and how you could develop a strategy to help fix a problem, or at least move towards fixing a problem, because you understand the foundation of why this works. I'm not necessarily going to tell you all the remedies for every situation. I'm probably not really going to cover that here. I'm just trying to help you understand that there is remedy if you understand how everything works from a commercial standpoint. So let's get into this article and you'll see what I mean. Okay, this is not legal advice, not tax advice. There may be misquotes and mistypes in this article. It's been passed around a few times. So do your own homework, but you'll get the concept, and that's what's important. So I came across this notice of Memorandum of Law, points and authorities in support of international bills of exchange. Now, am I telling you to go write bills of exchange? Absolutely not. But I am showing you that things you are doing are bills of exchange. You may already be doing it and not even realizing it. You need to be in control of your contracts. The key to being, if you want to, out of the system, or at least feel freer in the system, is to know how to control your contracts. The Bible says we perish for a lack of knowledge, not necessarily for the lack of a good attorney. In other words, it's our knowledge that matters, how the system works. Jesus didn't even like the fact that there were money changers doing business in the temple. Really, the message of that wasn't so much he didn't like them. He was trying to tell us that these guys are going to be the thieves that rob you if you're not careful. That comes right out of the Bible. And guess what? We've built a whole system around that. Yet, it does benefit them, and they will steal from you if you don't understand how the system works. How, in fact, you control the system by how you control your agreements and your contracts and things you get into. And a speeding ticket's a contract. A tax form's a contract. A mortgage is a contract. A loan is a contract. A student loan. These are all sorts of agreements that are created out of a power that you have. You have a unique power. So let's get into this and what it says. The premise. Banking laws, court rulings, trust laws, and the Constitution itself support the fact that every American is under the current system has the ability to create credit because we are the collateral providers and members of the National Banking Association. Our whole system right now is a National Banking Association, or in other words, it's a trust. And that trust is identified through the Social Security Trust, which is a cess-decay trust. You are the beneficiary of this trust. Now, why is this important that this is in place? Because you can control it if you understand what your relationship is to everything. So, anyway, our property and labor have been pledged as collateral for the national debt and the banking system. Our labor and our pledges, those are our contracts and agreements that produce a future contract performance value. Essentially, that's credit. Well, that's actually substance. That's the one form of substance we have, is you produce that substance. In other words, if I say I'm going to agree to something and I put it on paper, directly or indirectly, that paper itself starts to have value. It could literally be sold in our markets because it has a production value to it. Well, we're doing this all the time. The problem is we're handing over the power to somebody else. That's where we make the mistake. So our labor is real substance, collateral in our system. They took the gold and silver out of the system in the 1930s. They converted our system over to this totally commercialized system. And that is what it is. It's not good, it's not bad, it's not evil in my opinion. It's just what is necessary to operate in a system of bankruptcy. Because in bankruptcy, to keep a bankruptcy going, you have to keep putting collateral in. And what they've done is devised a system where we keep putting up our collateral, and due to our ignorance, we keep putting up even more when we don't need to. In other words, we're paying double for everything, and the bankers profit in the middle. Okay? So, as such a system exists, we have a remedy from government and some corporate debts. Since we have no money of substance to pay with, in other words, we have no gold or silver, and they won't allow gold and silver, they only allow us to use notes, debt instruments, to measure a discharge of something. Well, at least that's what you used to think until you know this. That's what you used to think. By debts, we mean certain public bills, utilities. I don't like utilities as much, but more like public bills, like a charge from a court, a lawsuit, a judgment, something that comes through the public systems, like taxes or other institutional claims against you, and even large banks and that sort of thing. They're part of that public system. They're handing you the remedy when they give you the paper, the bill they give you actually. It's called a coupon. Have you ever used a coupon at a store? Hey, if the coupon gives you something free, it pays for it, right? Well, they send you coupons. Keep that in mind. So we have no money to pay with. So by debts, we mean certain public bills and utilities, like I said, taxes, other institutional claims. Keep that in mind. These are actual bills. Even a criminal charge is a true bill. So therefore, our remedy, we can order the issuing of credit via the trust system. We all have a Social Security number, at least the one we use. It's not ours, it's theirs. We have access to it as a beneficiary. But we always step into the role as the trustee by taking the liability. We don't want to do that. So we can order the issuing of credit via the trust Social Security system by our acceptance of these negotiable instruments offered to us from public entities. Okay, again, civil, criminal charges, bills, judgments, etc. This is not for the mom and pop person you owe money to, or something involved really a physical asset that you've got to give back to somebody. This is just about paper matters, okay? And anyway, you can return that instrument to the trustee to discharge the debts. Okay, now that's along the lines of what we call subrogation. In other words, we're saying, wait a minute, I'm not assuming the liability. I'm passing it back to you. I'm subrogating it back to you. And so we've talked about subrogation in the past. That's really what you're doing here as well. You're saying, I'll take the position of beneficiary. I'm not supposed to be paying the bills. The trustee pays the bills for the trust. It's just that simple. You guys are the trustees. You take care of it. But if we don't understand why we can say that, you won't believe you can say it, and you won't do it. So anyway, this document is not to tell you how to do it, but it's to show you the foundation of why and how the legal and banking system actually operates in our life today. It's not about a checking account and an ATM card, and that's not the banking system we're talking about. When we are part of an association, in this association they're talking about, through all the language of this article, and I'm not going to go through the whole article, but throughout the language you'll see them referring to the National Banking Association members. We, you and I, are providing the collateral that keeps the system going. That's all there is to it. We are the constant, it's our property, our real estate. That's why you give away half your real estate value to the state and pay a tax on it. That's why you give a title to your car to the state. You actually give them an interest in the car. That's a tax. That's why you have to pay income taxes, to pay interest to the debt, and so on. You do need to do these things. I'm not somebody that says you have to be out of the system. I'm simply saying these contracts you're in, you can better control, and if there's something that's handed to you to pay as a liability, you can discharge it, or at least order it discharged by the trustee, because I can't do it, they can do it. I just have to understand my relationship to this bankruptcy that's going on, and I need to keep myself in the position of beneficiary. Subrogate. See, they assume I want to be the trustee and pay the bill. I don't have to. I want to be the beneficiary, so I subrogate back to them. All right? It's changing positions. That's all it is. So let's get a quick overview. When you're reading this material, those who constitute an association nationwide of private, unincorporated persons, that's you, engaged in the business of banking, that's you, to issue, because you're the collateral provider, to issue notes against the obligations of the United States due them. Who's them? Them is you and I. That's who they're talking about. The United States is the corporation that operates. They're the trustees. See, we can issue the note, give it to them, and they need to settle the debts. This is an obligation that's due to us. So, see, our private property is at risk to collateralize the government's debt and currency. By legal definitions, a national banking association is what it's called. So such notes issued against these obligations of the United States to that part of the public debt due, its principals and sureties are required by law to be accepted as legal tender. It's telling you can issue a note. Well, what if they actually give you the note to even just sign off on? It's called the coupon usually. Anyway, that's legal tender for the payment of debts, public and private, and are defined in law as obligations of the United States. The United States is that corporate entity in the District of Columbia. Go look it up. It's actually in dictionaries. That's who it is. It's not us. It's not the state you live in. It's the obligation of the United States. Just think of that as incorporated or the United States Trust, okay? They have the obligation. And it's on the same par and category with Federal Reserve notes and other currency and legal tender obligations. So if you understand the terminology used in this paragraph and you start looking at everything that's coming to you through any institution or government agency or whatever, through this lens, you'll start to see the remedies. So, items tendered for discharge of debt. And there are many kinds of commercial natures. Okay, there's many types, but basically, a court matter, a tax, a public institution type of debt. These are the things we're mostly talking about. Okay, the instrument tendered to the bank and negotiated to the United States Treasury for the settlement of an obligation of the United States. Didn't say obligation of you. It's obligation of the United States. Is under Title 18 U.S.C. Section 8, representing, as the definition provides, a certificate of indebtedness drawn upon an authorized officer of the United States. So in other words, that agent sent you a bill. And of course, the Secretary of Treasury is issued under an act of Congress. This gets into a Public Law 7310, HJR 192 of 1933, Title 31, U.S. Code 3123, and 31 U.S. Code 5103. Go look those up. I'm not making this up. This is where these things are discussed. And by treaty, in the United States, in the United Nations Convention of the International Bills of Exchange and International Promissory Notes, UNICETRAL, and the Universal Postal Union, headquartered in Bern, Switzerland. By the way, if you ever wondered where we're going to get an international government someday, folks, it's been around since before the forming of the country. The UPU was formed before even the United States. They manage the commerce, and commerce is everything. Everything is about commerce. Every war is about commerce. All trade is about commerce. Okay? So they've been managing it for a long time. Don't get all freaked out about, oh my gosh, we're going to have a one world government. Someday it's just going to be suddenly announced. It's been there the whole time. And the whole world operates under this entire bankruptcy system now because it just has to do with when the bankers basically took over. But the key is you don't have to be a slave to it unless you choose to, and you can choose not to by learning the basics of these contract rules I'm teaching you here. By the way, we spend a lot of time talking about these issues in our premium member calls, which we do a couple of times a month. If you're not a premium member, go to our join page up here on the upper left of the website. You'll see where to join and get membership information. Be sure you do that. You'll be able to get more and more in-depth discussion of these things. Further, we offer private coaching, equity classes, and private coaching on the subject to get into specific case matters you might have, or just to teach you a more in-depth way how to take all these documents they're presenting to you and convert them into literally the money to return to them and settle and close the accounts. And we don't do it with special tax forms or anything like that. It's just simply the way it's accepted, and what position we take, and our understanding of the language, and continuing to operate intelligently as one of the bankers. We are one of them. Why would we want out of that system? Our remedy's built into it. A lot of people want out of it because they don't understand it. But we perish for our lack of knowledge. Be knowledgeable, and that's what we're all about. We're not about completely destroying the system. In fact, not even really wanting to destroy the system. We just want people to understand how to better operate in the system. And that's what the true wealthy do. You don't want to have a small person's mindset. Have a wealthy person's mindset. They look at knowledge as a tool. Okay? So, Section 8, this is under Title 1, Part 1, Chapter 1, Section 1, Section 8. Obligation or other security of the United States. Remember, of the United States is an obligation of them, the trustees that run the U.S. corporation, run the bank. Okay? So the term obligation or other security of the United States includes all, and by the way, when they use the word includes, it means only includes, by the way. That's just another legal definition. So all bonds, certificates of indebtedness, national bank currency, Federal Reserve notes, you've heard of those. You're carrying them in your pocket right now. Federal Reserve bank notes, coupons. They mail you a coupon in the mail. It's at the bottom of every bill that you get from a commercial entity or government. United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposit. You probably might have had one of those maybe at one point. Bills. When you get charged with crime, they give you a true bill and they hand it to you. Checks, you might have used those. Drafts of money, maybe you've used those. Drawn or upon authorized officers of the United States. Okay? Stamps or other representatives of value or whatever denomination issued under any act of Congress or canceled United States stamps. Even canceled stamps are money. This is money, guys. When you run around saying, I have money, these are included in what you would call securities of the United States, which you can use as money. Okay? And did you notice bills, drafts for money, coupons? It's right there in the definitions. So, the International Bill of Exchange is a legal tender as a national bank note or note of National Banking Association. Remember, we're members of the association by legal and statutory definitions. Okay? I'm going to browse through this. It goes back and it's part of the issued in accordance with 31 U.S.C. 3123 H.J.R. 192, which establishes and provides for the issuance of as public policy in a remedy for discharge of equity interest recovery on that portion of the public debt to its principals, that's us, and sureties bearing the obligations of the United States. So, in other words, they send you something through the system, it's public policy that they should have to give you a remedy for discharge of public debt. Because they took all the money in 1933, basically, and all the gold and silver, and they said, here's what we're going to give you in exchange. People say, well, that was theft. Well, it's theft if you completely don't understand it. You do have to have full disclosure, but they did give full disclosure the way they published it and everything. The question is they didn't teach us how to actually operate in the system. But this is the system, and it's available to you. You just have to invest in it and know that the background is there to cover you. All right? So this is the statutory remedy for equity interest recovery due the principals and sureties, due the principals and sureties of the United States for discharge of lawful debts in commerce in conjunction with U.S. obligations. Remember, they're the ones obligated to pay it according to H.J.R. 192 and others. To that portion of the public debt it is intended to reduce. And by the way, this is a really important point a lot of people miss. They think if I spend it with Federal Reserve notes, I'm paying the debt. No, you're paying a debt with a debt. You're increasing the debt. But when we take the debt and we use it to discharge, we are discharging actual public debt. And therefore, we're actually reducing the national debt, according to this statement. See, during the financial crisis in 1933, the substance of gold, silver, and real money was removed as a foundation of our financial system. You can go look this up. Okay? We didn't make this up. In its place, substance of American citizenry, their real property, wealth, assets, and productivity that belongs to them was in effect pledged by the government and placed at risk as the collateral of the U.S. debt. And that's when the Federal Reserve went off and started printing money, because they had collateral. People say they print it out of thin air. No, they don't. They base it upon some calculated value of assets that are there. That includes, by the way, your labor. Remember that. Productivity is a measure which is used to determine if there's enough future value to pay off those debts they're creating. We can fix this problem, though. We can fix the problem by learning how to, instead of using debt to pay debt, learning how to accept and discharge it. Okay? And that's how the credit and currency for commerce system is designed to function. So it's well documented in the actions of Congress and the President at the time that in the congressional debates that preceded the adoption of the reorganization measures, look up any Chapter 11 definition you can find. It'll talk about reorganization. Senate document 43, 73rd Congress, first session stated, under the new law, the money is issued to the banks in return for government obligations, bills of exchange, drafts, notes, that's something you can write, trade acceptances, bankers' acceptances. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It's not backed by an asset, it's backed by credit. Whose credit? Who's the creditor? Who's the one giving the credit? Do you think the government has anything? No, it's you. And this will represent a mortgage on all the homes and other property of the people of the nation, which lawfully belongs to the private citizens. So in other words, they've mortgaged everything. You don't really own anything. And a lot of people are out there trying to get a Lodio title and get the title back and all that kind of stuff. No, folks, we operate under a trust. You can't go in there and steal property from a third-party trust, even though you think you have an interest in it. No more than I, as a stockholder of Microsoft, can walk into the Microsoft Corporation's headquarters up in Seattle and start taking computers because I'm a stockholder. I can't do that. There's an arrangement now. I have the use of all these things, and I don't have to pay the debt on these things. That's the thing. See, you can have both the use and have the debt satisfied, but you really don't get real title to anything anymore. It's all part of one big banking association. But you need to learn how to better operate within your position within that association as a beneficiary. Get to know that term. You're the beneficiary of it. They can't steal from the trust because that's stealing from you. And everything that operates in our system is designed to protect the trusts. Protect the trusts. And an antitrust act is a very serious thing. So they operate in this bankruptcy. We continue to provide collateral, but it doesn't mean we're giving up everything unless we decide to take on the liability as well. No, they have the liability. That's the whole point. That's the subrogation. You simply take away the presumption, let them know that, no, sorry, I'm just merely the beneficiary. As far as I understand, you're the trustee, you take care of this. And that's kind of how we take it. When they send you a coupon, they sent you the money. Remember I told you up here above, notes and coupons and bills, things like that are actually the money. So give that back to them with their direction to settle it. That's the key to much of this concept of discharge. And it's not accepted for value. That term doesn't exist. It's another way of doing it, which we teach in much more depth in our equity training. But if you get the basic understanding, at least you know where to start, and you've got a foundation for what you're doing. Okay, there's a process for some of this that works, and there are many processes that don't. Certainly, writing something called a bill of exchange and sending it to them is not a good idea. Promissory notes might work, acceptances might work, but again, you got to do it right with the right language and get the right recognition of the instrument and use the right instrument so that you're not creating something out of thin air, or you're not using an IRS form for something it wasn't intended, because then you can get hit with a fine for that. So you can do a lot of things, but just understand there is a foundation, and then there are a couple of proper ways to do these types of things. Again, we try to get into more of that training on our premium membership, but more so in our equity training at urlaw.org. So the national debt, you hear about all the time on the news, is defined as mortgages on the wealth and income of a country? Well, really, it's a trust. It's a trust because that's how it's all organized. That's the treasury is the bank account. And we're all beneficiaries of the trust. That's the way it's always been. It's actually been that way. The Constitution itself was a trust agreement. Okay, it's just been modified over time because of changing financial circumstances for the country. So, and their wealth, their income, the reorganization or bankruptcy, that's really what a reorganization means, it's bankruptcy, is evidenced by the Emergency Banking Act, House Joint Resolution 192, series of executive orders that go on over time, like, when they took us off the gold standard, that was an executive order, reopening of the banks, transition from foreign exchange, transactions in foreign exchange are permitted under governmental supervision, forbidding the hoarding of gold, silver bullion, that kind of thing, gold certificates. All that happened in 1933. And then even going back to 1913 was part of the development of the process. They provided an act to provide the establishment of a Federal Reserve banks, that banking system we have today, to furnish an elastic currency to afford, which basically means credit that could vary in value, to afford a means of rediscounting commercial paper to establish a more effective supervision of banking in the United States, and for other purposes. The act is commonly known as the Federal Reserve Act. Now, you've heard people saying abolish the Fed, do this, do that. Maybe they need to do that. But I can tell you, if you're knowledgeable, the system's not a bad system. It is what is necessary when we're operating in bankruptcy. And we're all part of it. You can try to get out of it and go live in a cave and kill water buffalo for dinner if you want to. I choose not to do that. I just control the contracts. I control my licenses I get when I need it, registration in a car, how a title is recorded. I put additional language on there to limit my liability and to reestablish my position as beneficiary. And then when I issue the debt comes related to that, I can handle that. I know how to issue accept the coupon or the bill and return it for settlement, and then have them settle the account. But they're not going to make it easy. So let's be really clear. You just don't say these things and then they run out and start doing it. They're going to throw it right back in your face because they will test you. They're going to see if you actually know what you're talking about. So this article is designed to give you a little more in-depth background. Now, I'm not going to go through the whole thing, but it gets into 12 U.S.C. 411, how we can issue lawful money as deposits and so forth. That's very important because that has to do whether it's taxable, because they tax the Federal Reserve notes, not the lawful money. But you have to declare it properly. Once declared, that could be a benefit to you. I'm not telling you how to file your taxes. I'm just simply telling you how to handle money in a way that may create less of a liability. Okay? Again, do your homework on that. We always see that term, full faith and credit of the United States, which is the substance of the American citizenry. In other words, it's you're backing it. It's there all the time. You think that's some money hole that's in the District of Columbia full of gold. No, it's you. You're the full faith and credit. Okay? And your real property, wealth, assets, and productivity, but it belongs to them. It was given to before birth. When the birth certificate was even signed, they made you part of the bank. You were a member of the credit union, if you will. Now you have to learn how to operate, but we never really were taught how to operate, so it benefits us. So it all defaults over to the government. It gets big, fat, and bloated because they get access to all this money that nobody's claiming, or credit, if you will. Maybe I shouldn't use that word money. But the point is the more lazy we get, the bigger government will get, and the more it will dominate us because they are holding our assets and we're doing nothing about it, instead of us directing them to handle things correctly. Okay, these are obligations of the United States, them, as trustees, for our benefit. But if we don't identify ourselves as that, it won't work. So in other words, when taxes and customs and dues are due, we should be able to get those things settled. And we can and do when we're knowledgeable. So I'm not going to go further into more of this article. I want you to spend some time going through this. It's on the website. It's a blog article that's there on the banking system. And, get over to the blog articles. You'll find it. You have to be signed in as a member. Okay? But You're a member of a banking association. You just don't know what role to play. You are the beneficiary. You should tell the public trustees to do their job. That's all. Instead of taking on the liability all the time, even a criminal charge, unless somebody is harmed, because then it jumps into the common law area. That's where they're going to deal with you more directly. You kill somebody, you're not getting away with something. You harm somebody, you're not going to get away with something. That's not the goal. I want those people in jail too. But it's the do no harm principle. But if you've done no harm and it's merely just a financial matter that could be zeroed out by the satisfaction of the public debt, well, that's the type of thing you can use this on. Okay? Again, I have all the references here. House Joint Resolution to suspend the goal. Here it is. The language is there for you. And if I'm wrong, go look it up yourself. Verify the wording is correct. Okay? And again, remember, membership details are at yourlaw.org/join. Go there to get in more depth. And then once you become a member, you can access this article free. It's right there in the blog section. The various codes that come out and say this. See, when we look at this stuff, we're not looking at it from the language point of view. In other words, what's the definition of these things? You don't see yourself as being part of the bank when they're referring to bank law. You're the collateral provider. You are one of the members. You put up the collateral, and you are doing it every time you produce labor, every time you produce a contract, every time you sign a tax form. You're creating future value for the big contract for the bank. Everything you put your name on and sign, they deposit as value because you're still around producing something. So it gives some value, so they can keep running the mill of money, right? So you can complain about the Federal Reserve. I think they do need to keep it under control, obviously, because the more we have to keep producing more debt to pay the debt, it's going to get worse. This process we're talking about here is how to pull back the debt. It's the only way to do it, actually, is take the issuance of the credit and give them the credit to settle the accounts. It actually zeroes the accounts, as opposed to creating more debt. When you use Federal Reserve notes, it actually takes money. If you're paying a debt with a debt, it just increases the debt. So you can do this if you understand the concept of it. But you can't. There's no magic piece of paper you can just sign and it just happens, because they will test you. So you've got to have a little background. This article is designed to give you the background, and it's absolutely free to anybody who wants to see this article. It's any free level member or above can read this article. Okay, but remember this: we are those who constitute an association nationwide of private, unincorporated persons engaged in the business of banking to issue notes against the obligations of the United States. Remember that sentence. Memorize it if you have to. It's due to us, them as us, those whose private property is at risk to collateralize the government's debt and currency. Okay? By definition, it's a national banking association. So we're the ones that can resolve these debts better. You have unlimited money. The Bible even says you have access to unlimited power, if you will. So why aren't you using it? When they built the system, they understand how it works. I don't care whether you believe in the Bible or not. It's right in understanding how the entire trust of the world works. Trust in me. You've heard Jesus say that. They're trying to teach you bank and trust law in that book. Now, you can see it as a spiritual guide. That's totally fine. But you see, there's far more real basic content there. And our system is built upon that, whether you believe it or not. It's like saying, I don't believe in gravity. Well, sorry, it still exists. That's the case of how debts and principles of money work. Okay? We didn't just invent all this stuff. It's a principle of nature almost. And they're explaining it to you here. And you have the authority as a beneficiary of the trust, not as the trustee is the guy that has to write the checks. That's not you. They try to hand that to you and see if you'll do it. When they hand you a criminal charge or a civil charge, they ask you your name, and if you're a U.S. citizen, and you start identifying, what you just did is you identified as the trustee, the liable party, when it's just a paper matter. Now, if it's a real matter, somebody's harmed, you got to resolve that. Okay, we're not telling you how to get away with something again. But if it's just really a fictional paper matter, you can balance the books by telling them to issue the credit by your authority. But you can't do it. I can't act as the trustee of a trust if I'm the beneficiary. I can't be both. I'm the beneficiary. You guys take care of it. I might be an executor to tell the trustee to do it. That could also be a position I can hold, but I can't be the trustee because the trustee's liable. They all take an oath to be trustees. That's what the oath is about, accepting the duty. So continue to read the article, folks. I'm not covering everything here. It's full of great stuff. Feel free to use it as you want. Do not copy and paste this into a document. Do not do that, because you don't know which parts are commentary, which parts were directly from the law. If you can reference the law, go look it up and use that. Okay? Just don't let them fail in their duty, because you go silent. Once you understand that you can tell them to issue the matter, and if they give you a piece of paper with something to put a signature on, you can accept it and return it, along with a notice. It's very important to put a proper notice together. That's what we use. That's what does it. And we don't have to cite the law. They already know it. We don't have to do that. We just have to understand how the law works when we do it. So we understand what they're obligated to do. Okay? So when a commercial bank sends the instrument to the secretary for discharge of its own obligations, and a problem arises concerning the instrument, a commercial response of some kind is required. This is where they get us. They don't always respond. This is why we have to give notices and follow-up notices. Then we can show that we followed the law and they failed in their duty. That's why we do a notice and a follow-up notice. That's called the administrative process. When we talk about the administrative process, it's not a magical, you have to do it word for word. You understand that it's a 2 or 3 step notice process. And then finally they default in failing in their duty to fulfill a public duty. Trust violation is a serious matter. What you're demonstrating is that they're violating a trust. Okay? They have a legal liability for the government to a negotiable legal tender obligation upon the United States government that's sent to them for acceptance by a member. Okay? Federal Reserve Bank, they have to accept it through their system after they receive it, and they become responsible for it. If it's been accepted by us, though, and then they have to accept it, that zeroes the account. It's done. There is no money to pay with. You can't pay a debt with a debt. Well, you can, as far as bookkeeping, they'll do it, but you don't see the other side of the books, which is increasing the national debt every time you do it. It's creating a problem. And you don't have to go do it that way. Okay? So again, read through all this. A good summary here you can go through. They got to treat that instrument you tender after you accept and return it with a notice as an obligation of the United States to settle. That's the bottom line to all this. The tender of these instruments discharges the obligation for the debt which they are delivered, and the payee becomes the new holder. They're the ones payee means you send it back to them for them to pay it and settle it. They become the holder in due course and the collection agent for the instruments. They've got to go do whatever is necessary. I don't try to explain it to them. I don't want to know everything. They just got to do it. So anyway, a little more information. If you want to learn about our membership levels, go to yourlaw.org/join. If you want to learn how to properly accept, settle, and close offers presented to you. Premium members, we discuss that, but we don't go into the full analysis of that until somebody joins our equity coaching or equity classes. Again, you can get details here on the website. There's a whole section of the website that gets into upgrades, coaching, different things. We even have status and wealth protection coaching, teach you how lawful money works. That's a separate coaching. The equity discharge class, that's already started this term. We do start them on occasion. There's no guarantee we'll do them again in the future. We're still analyzing that, but we do private coaching. We can walk you through some of that as well for a given matter. It's very time consuming, so you remember a man is worthy of his hire. You don't expect a lot of free advice and giving you access to everything that people spend a lot of money to learn how to do, but we will give you what we can if you want to get into more of a private coaching arrangement. And then these are other areas that we get into, criminal case coaching. Sometimes we use the same strategy for that, and sometimes we use another strategy. It just depends on the situation. But come to our website. We have various member levels, areas you can get into. You learn about the member levels here under the Join, Upgrade, or Coaching link, and find this article under the blogs. Again, if you get a little lost on the blog, the title of this is A Historical Basis Why You Can Discharge Debts. And of course, we have some categorical headings to help find these under as well. Take the time to look around. We'll see you all soon. Thank you for taking the time to look at this video. I know it's a little bit long, but I think you'll find that it'll answer a lot of the questions people are seeking out there in the patriot movement, because we don't like to think of ourselves as patriots. We try to think of ourselves as knowledgeable. And knowledge is going to get you a lot further than protests and arguing and debating and trying to get revenge. We don't do any of that. That's not what we're into at all. But we'll show you how to get your rights back by understanding that everything is just a contract. And everything can be settled the proper way. So until we speak as a member, thank you. We'll see you at urlaw.org.